This is a lecture about the insanity defense. Now, there are two major areas, sub-areas of law here. One are the procedural issues that are procedural rules you need to know surrounding the insanity defense. And the other is the substantive rules about how do you decide if someone is crazy enough. With regard to the procedural rules, the kind of thing we want to know are such things as how do you raise the defense at the trial? Once you've raised it, who has the burden of proof? What is the difference between being insane at the time of trial and insane at the time of the act? If the person proves that they are insane at the time of trial, what happens to them? If the person proves that they were insane at the time of the act, what happens to them? And when these people get committed to institutions, how do they get out? What do they have to prove in order to get out? Those are the areas where there are some procedural rules that we need to know, not very many, but just a few. We need to know about that. And then secondly, the substantive material is based on the concept that a person is entitled to a verdict of not guilty by reason of insanity. Person is entitled to a person is entitled to a verdict of not guilty if their mind was broken, their brain was broken enough. Once again, the basic rule is that a person is entitled to a verdict of not guilty by reason of insanity. They're entitled to be acquitted by reason of insanity if their brain is broken enough. And so obviously there's a lot to be talked about here about what do we mean by their brain is broken enough. We'll talk about that. So those are the two areas. How broken does their brain have to be, and these procedural areas that we talked about. Now ordinarily the way you do this is you do the procedural stuff and you do the substantive stuff. But in order to understand the procedural stuff, there's certain things about the way the legal system looks at the brain that we need to talk about, and that's on the board. So let's talk about this first, and then do the procedural stuff, and then do the substantive stuff. Then we'll do a couple of examples. Here, drawing a person with a brain. And from a legal perspective, the way the brain works is that you have this incoming information to the brain. Now this incoming information is really just a series of electrical impulses going up the spinal cord or someplace up to the brain. So this collection of electrical impulses, when it gets here, the brain has to interpret those and decide what it means. If this part of the brain is wired, is defective, if this circuitry here is defective, then the incoming electric pulses that may be interpreted to lead this person to think that you really are rubbing a lemon when the person is choking somebody to death. And so if this wiring here is that defective, then this person does not know what they're doing. Now, even if the wiring, and the wiring of course can be so defective that they really don't know what they're doing, but it can be less defective, so maybe they can't appreciate what they're doing. So you can have degrees of this, and the McNaughton rule, as you can imagine, requires totally you did not know what you're doing. So the brain can be wired so that they didn't know what they were doing. Secondly, when the person thinks they know what they're doing, the next question is, did they know that there was anything wrong with what they're doing? And how do you decide whether or not you think something wrong? The answer is that you get a standard, and you compare your conduct against the standard. Is this a criminal wrong? Is it wrong in a social sense? Is it immoral? Did God told me to do it? Is it still wrong? And so what you have to do is to compare the act. What the person has to do is to compare their present act with some standard. Now the two things that can go wrong here. Number one, two problems here. One is that this circuitry that pulls up some standard and takes a look and compares, that circuitry may not work. When you can turn on your television, it just doesn't do anything. So this circuitry just may be broken, doesn't work at all. So this person doesn't even have the ability to decide whether or not what they're doing is right or wrong. On the other hand, maybe they can get some inkling and it's not so clear. So even if you know what you're doing, the person may or may not be able to determine whether it's wrong. And even if they have the ability to determine what's wrong, what standard should they use? So the problems that can go wrong here again, didn't know what they were doing, didn't know it was wrong. And what standard do you use? Next, once the person knows what they're doing, or they think they know what they're doing, the person normally responds in some way. Now, if the person is able to control their response, that's fine. But suppose this response mechanism, the circuitry here, is defective in some way, that the person is unable to control what they're doing. So we now have several possibilities, 3 to be exact. The person may not know what they're doing, they may not know it's wrong, they may not be able to control it. Now, various degrees of these is what the criminal substantive law is about. We'll come back to that. But we understand the basic strategy of how the brain works. Now, with that in mind, let's turn to the procedural rules that we need to know in this area. And then after the procedural rules, let's come back and look at the details of the 4 ways and the 4 sets of rules that you use to decide whether or not the person is insane based on the drawing that I showed you. So, getting to the procedural issues, first, the defendant has to give notice to the prosecution of intent to use the not guilty by reason of insanity. Now, mind you, when a person is not guilty by reason of insanity, what that means is the person did it, but they're going to get acquitted because of insanity. If they didn't do it at all, then they're just not guilty. But if they're not guilty by reason of insanity, they did it, but they're being acquitted because of insanity. If you're going to use that defense, you have to notify the prosecution, because the prosecution has to have time to prepare for that defense. It's a big deal. Either the prosecution is going to have to prove that the person was sane beyond a reasonable doubt, or the defense is going to have to prove that the person was insane with the preponderance of the evidence. And in either case, the prosecution's got a big job ahead of themselves, so you got to give them notice if you intend to pursue this defense. Secondly, this defense is not required by the Constitution. All states have one. And thirdly, about half the states have an all or nothing rule. What is this all or nothing rule? Well, the all or nothing rule says that you cannot use the state of mind of the defendant as a defense unless you're pleading insanity. You know, we're not talking about drunk driving cases and that stuff. But you go out and kill somebody and want to offer the insanity defense, you can do it. But suppose instead of offering the insanity defense, you say, look, you know, my person isn't insane, because you can get somebody determined insane. They may be in jail forever, even though they didn't do much. But you're saying, my client is not insane. My client simply could not form the intent to do this kind of crime. My client has a lobotomy. My client brain works in such a way that he sees the world as though he's on acid all the time. And so my client does not have the ability to premeditate. So we're saying that since you got to this crime that my client is charged with, you got to prove the mens rea and the actus reus. And as to the mens rea, my client can't form that. They can't form intent and so forth. But they're not crazy. And the courts, half the courts in the states have said, no, you can't do that. all or nothing. That if you're going to do that, then you have to claim insanity. Now, mind you, you can claim that your client did not have the state of mind required for the crime. That's different from saying my client is crazy and they could not have formed it. We're not talking about that. But every crime has a mens rea and an actus reus, so you can claim my client didn't have the mens rea. But that's different from saying my client's brain is broken and they couldn't have formed the mens rea. So some jurisdictions, about half of them, say you cannot offer the claim that your client couldn't form this state of mind unless you're offering the insanity defense. So it's an all or nothing in those jurisdictions. You're insane, and everybody who is on the sane side of this is treated alike. Okay? Now, the half of jurisdictions that don't do that, they say, well, you can be insane, but you can also, have diminished capacity, and that we'll let you show that your person could not have formed could not have premeditated, could not have formed malice in their minds. We'll let you prove that without necessarily having to prove the person was insane. So about half the states follow the all or nothing rule. So the basic rule here is you've got to give the prosecution notice. Secondly, the defendant has to offer credible evidence of insanity in order to raise the issue at trial. And it doesn't take much. The defendant can just put on a neighbor who says this person has been acting erratically. I mean, that's probably enough to raise the issue of insanity at the trial. Now, once you have raised the issue of insanity at the trial, if you don't do this, people are presumed to be sane if you don't do this. But if the person puts on credible evidence of insanity, and almost anything, then about half of the states, the prosecutor must prove sanity beyond a reasonable doubt. It's treated like an element of the crime. In the other half of the states, the defendant must prove insanity with a preponderance of the evidence. And finally, in the federal system, the defendant must prove insanity with clear and convincing evidence, higher standard. Continuing with our procedural issues, that brings us to the third one, insane at the time of trial or insane at the time of the act. Now, if the person is insane at the time of the trial, first of all, how does this issue come up that the person is too insane to stand trial? And the answer is that the issue can be raised by the prosecutor or by the defense or by the judge. If the issue is raised, the test now is different. The court then sends the person out to a mental institution to be tested to see if they're sane enough to stand trial. But how sane do they have to be to stand trial? What is the test? And the test is that the person needs to be able to understand the proceedings against them, and the person needs to be able to assist their lawyer. Now, in a case of a crime, for example, the person who knows the most about what happened at the scene of the crime is the defendant, who was presumably there, unless they got an alibi. And so if that person who was there knows the most about what happened, cannot assist the lawyer in their defense, you can see that's not a fair trial. So the defendant has to be able to assist counsel and to understand the proceedings against them. And if they cannot pass this test, the consequences are that the person is committed until they're sane, so they can stand trial. But the defendant has to show some progress towards becoming sane, because otherwise the person could be there forever, for life, waiting to get sane enough so they could stand trial for something. Consider a person, for example, who was born with an IQ of 60, and let's suppose that was enough to make this person qualify as insane for legal purposes. And at trial, the person says, I'm insane. They're insane in trial, so the court sends them to an institution until they can get sane. Well, they're never going to get sane. The IQ is 60. It's going to stay there. And so you can't do that indefinitely. You have to, the person, there has to be some progress shown that the person is progressing, becoming sane, so one day, reasonably soon, they can stand trial. But if they're not making substantial progress towards becoming sane, then the state has to move over to a civil commitment proceeding to see if this person can be civilly committed, because they can't just wait for trial forever when they're not making any progress towards getting sane. So the rule or the consequences of establishing that the person is insane at the time of trial, consequences are they're committed until they're sane, but the defendant must make progress, or the state will have to go to civil commitment proceedings. Now, the insanity that the person has to establish at the time of trial, saying they're too insane to stand trial, that is different. The standards are different. The standards are the ones we just talked about. Can they understand the proceedings and can they assist? That's very different from the standards that you would use if the question is, was the person insane at the time of the act? That's when you use those four forms of insanity, four rules of McNaughton, the Model Penal Code, the Irresistible Impulse, and the Durham. Now, let's come to the last of these procedural things, insane at the time of the act, not guilty by reason of insanity. In that case, what happens to the person? There's what happens, three different possibilities. Under the federal system, the person who is not guilty by reason of insanity, the judge is required to commit the person to a mental institution. In many state courts, the person has to be sent to a hearing to determine whether or not they should be committed to a mental institution. They almost always are. And in a few states, the prosecutor gets to decide if the person should be committed to a mental institution. Now, once a person has been committed to a mental institution, please notice that the jury is not told that if you find this person insane, that there will be a civil commitment. The theory is that the jury is not told if the person is found guilty, how many years they're going to get in jail or what's going to happen to them. The jury is not told what the consequences of finding them guilty. They're just supposed to answer the question, did the person do it or not? And so in these insanity cases, the same concept applies. The jury is not told that if this person is found insane, they're not going to go back on the streets. They're going to be put into a mental institution, maybe for a very long time. But the jury's not told that. Finally, if the person's in a mental institution, when do they get out? And the answer is that to be in a mental institution because the person is insane, the rule is they got to be dangerous to themselves or others. They have to be insane and dangerous to themselves or others if you're putting them there because they're not guilty by reason of insanity. If they're not guilty by reason of insanity, you've established that they're insane, and if they're dangerous to others, you keep them there. Now, to get out, the person has to prove either that they're not insane or prove that they're not dangerous anymore, either one, and they get out. Because if the person is insane but not dangerous, they shouldn't be in an institution. They're just not dangerous, not to themselves or others. On the other hand, if the person is sane but dangerous, well, there are lots of people walking the streets right now who are sane but dangerous. You can't lock them up till they do something. And so if the person is insane and dangerous, they remain institutionalized. But if you remove either one of those, you've got to release them. And finally, states like California have a bifurcation procedure which is not likely to be tested. So those are the procedural issues, and we now want to turn to the substantive issues. And let me tell you about those. Now, first of all, we know that there's a McNaughton. We know there are four ways. Let's back up for a second. What we're trying to decide is if here's where the brain decides what the incoming signals mean. And if this is defective, the person doesn't know what they're doing because they think they're doing one thing and they're really doing something else. Okay, that's the McNaughton rule. Or if they don't know it's wrong, and they could not know it's wrong because this part of the brain just doesn't work. And now the question, of course, becomes, well, how total does this defect have to be? And some of the later rules, like the Model Penal Code rules, begin to soften these. The McNaughton rule says that the person doesn't know what they're doing. I mean, doesn't know what they're doing. I mean, that is very crazy. If you're squeezing your neck and you think it's a lemon, this part of the brain is very defective. The person doesn't know what they're doing, or they didn't know it was wrong. Very high standards. As we will see in a few minutes, what the Model Penal Code does is says, well, let's not be so absolute about didn't know what they're meaning. If the person lacks substantial capacity to appreciate what was going on, that might be enough. And the same thing here. And some jurisdictions don't allow this branch at all. In fact, a lot of jurisdictions don't allow this branch, probably half of them. This is the branch that says couldn't control the impulse. And the reason a lot of jurisdictions don't allow this is because it's really, really difficult to figure out whether somebody could not resist what they did, or they simply did not resist what they did. And the psychiatric community says we don't have a way to tell whether the person could have resisted that and just didn't. Whereas if a person, you're sending signals to their brain and you're sending next signals and the person thinks it's a lemon, there are ways to determine that. So you can measure that the person doesn't know what's going on out there in the world, they're getting it wrong. You can measure that the person can't distinguish right from wrong, but you can't really easily measure that the person could have resisted that. And so because this is not very measurable, a lot of jurisdictions don't allow it. The federal rules, for example, don't allow it. The McNaughton rule says if the person did not know what they were doing because of a disease or defect, didn't know what they were doing, or didn't know it was wrong, then that's insane. Notice that the McNaughton test does not deal with this at all. This side over here is called the cognitive test. Cognitive test because this is the way the brain works to figure, you don't know what's happening, you don't know what's wrong. This is figuring out things. This is the cognitive side. Over here we call this the volitional side, the acting side. And so the volitional component here this component is not present in the McNaughton, whereas the McNaughton does use this over here, and this is cognitive. This part here. This is cognitive. Now, what happened with the McNaughton test is that the courts, the majority rule in the country is McNaughton, but the majority rule of McNaughton doesn't have a volitional component. And jurisdictions that follow McNaughton says, well, we really think there ought to be a volitional component. So more than half, or at least approximately half, of the jurisdictions that follow McNaughton, and that's the majority rule, about half of the majority, in fact, the majority, I know it's, as a matter of fact, the majority of the jurisdictions that follow McNaughton have added a volitional component to McNaughton, okay, saying if you can't, if you're unable to control the response, that's also a form of insanity. So now with those thoughts in mind, let's look at what the rules are and see some examples of how to use them. First, the McNaughton rule. The McNaughton rule says that it says because of a defect, pardon me, got it wrong, sorry about that, because of a disease or defect of the mind. You can use mental here. Because of a mental disease or defect, the person did not know the nature and quality of their act, or did not know the wrongfulness. Did not know it was wrong. So that's the McNaughton test. And what the McNaughton test says, did not know the nature and quality of the act. And be sure to put that nature and quality in there in your answer. I know it's a nuisance, but put it in there. Because of a mental disease or defect, that's first. Did not know the nature and quality of the act. And the, or did not know it was wrong. So, the did not know it was wrong. We have a problem here. Do you mean legal wrong? Do you mean moral wrong? And the answer, most jurisdictions, is either one of them. Did not know the nature and quality of his act. What happens here is that under the under the federal rules, say the person, it's not that they did not know the nature and quality of the act, is that they are, under the federal rules, they are unable to know. Under the California rule, we say the person has to be incapable of understanding. So you see that the federal rules have taken this very seriously. Unable to know, and there. And now let me put one more branch. Well, okay, see that. Next comes the irresistible impulse. And I said to you a few minutes ago that although this is the McNaughton standard, it does not have a volitional component. And a lot of states have decided, over half of these states have decided that we're going to add, so here, most states added the irresistible impulse to this. Next comes the irresistible impulse itself. And the irresistible impulse, the rule is that the person could not resist it. Now, this is a misnomer, and all the books recognize it, because the irresistible impulse defense does not require that the person really acted on an impulse. I mean, you could think about it and plan it and all that sort of stuff that you want to. If you couldn't stop yourself, it doesn't matter. So the impulse is really not required. And finally, the irresistible, well, just how irresistible does it have to be? And this makes it sound like absolute. But in practice, it's not absolute. Not absolute in practice. Also, up here, where states have added the irresistible impulse to their McNaughton standard, when states have done that, they use these same standards here, that the impulse doesn't really have to be an impulse and doesn't have to be absolutely irresistible. You know, it's just close. Next comes the Model Penal Code. And what the Model Penal Code does is to soften the standards. Here, and these people have got harsh standards, did not know the nature and quality, unable to know the nature and quality, incapable of understanding the nature and quality. And also down here, I left this out, let me add it in here, that they were unable to know that it was wrong or incapable of knowing that it was wrong. So this wrong part here applies there. So you have the legal and moral issue, and you also have the California and the federal components that we're talking about here. Under the California rule, the person must be incapable of understanding that it was wrong. Under the federal rules, the person must be unable. I don't think there's any difference between those, but the language is different. Unable to know. Then comes the Model Penal Code, and the Model Penal Code says, hey, you know, we're going to soften some of these boundaries. And what our rule is that because of a mental disease or defect, because of the mental disease or defect, the person lacks, the defendant lacks substantial capacity to appreciate, notice the softening, to appreciate the wrongfulness or appreciate I'm sorry, substantial, I didn't mean to put this here. Lacks substantial capacity to appreciate the wrongness or to conform the conduct. To the requirements of the law. So under the Model Penal Code, a person doesn't have to be so crazy that they don't even know the nature and quality of the act. They're saying that if they lack substantial capacity to appreciate the wrongfulness. Now notice they don't put nature and quality and wrong, they just put wrongfulness here. That's good enough. Because they're saying the nature and quality doesn't need to be separated from wrongfulness there. So they're saying here, the Model Penal Code, that under the McNaughton rule, the person does not know what they're doing. Under the Model Penal Code, they lack substantial capacity to appreciate the wrongfulness. It kind of combines them. Lacks substantial capacity to appreciate the wrongfulness of the conduct, and that's enough under the McNaughton rule. I mean, under the Model Penal Code. Finally comes the Durham Rule. And the Durham Rule is the product rule. And the product rule says the person, first of all, I don't think anybody follows the Durham Rule, so don't spend a lot of time on the bar exam. It was adopted in 1954 in Washington, D.C. by the Federal Circuit Court there. And but 18 years later, nobody had adopted it. None of the courts had adopted it. None of the circuits had adopted it. And Maine, the legislature of Maine had adopted it, but that's the only person who had adopted it. And finally, 18 years later, even the circuit court that came up with the Durham Rule abolished it in favor of the McNaughton Rule. And so the federal courts now follow something, so nobody follows Durham unless the legislature in Maine, I don't think they do, still follows it. But you need to mention it, and it's too hard to use. Nobody knows what's a product of a disease or defect. Now, so when you have to decide whether or not the person is entitled to an acquittal by reason of the fact that they didn't know what they were doing, by reason of insanity, you'll use one of these tests, either the McNaughton, we understand what it says in general, we understand what McNaughton says in the federal rules, we understand how McNaughton is interpreted for California, we understand that they also did not know it was wrong. These same standards apply. And that in the federal rules, they have to have, under the federal rules, unable to know it was wrong. And in California, by the way, two things. Let me tell you something else about this federal rule. The federal rule says because of severe, so the federal rules says because of severe. I don't think this makes any difference. But the federal rule says because of a severe mental disease or defect, the person was unable to know the nature and quality of their act, or the person was unable to understand that it was wrong. But they have to have a severe mental disease or defect. And the authors kind of laugh at this because they say, if a person is this crazy, it's already severe. So that didn't really add anything. Secondly, in California, an interesting little point is that in California, the person has to be incapable of understanding what the nature and quality of what they're doing, and incapable of, and in California, it's not or did not, incapable of understanding that it was wrong. In California, it's an and. So California, this is an and. So in California, to qualify for insane, the person has to be incapable of understanding the nature and quality of their act and incapable of understanding that it was wrong. Now, with that in mind, let us do a quick example and then let's quit. From the bar exam, I think it's the 2007 exam, I think. There was a person in a grocery store who had been in and out of mental institutions all of his life. And one of the customers in the grocery store, in dealing with this person who was not mentally stable, said they had a little conflict, and the person said, you ought to be locked up. And the employee hit the customer. Customer fell, hit his head, died. So first of all, you have the question of, is it first-degree murder, is it second-degree murder, is it voluntary manslaughter? So you go through that stuff. But on the insanity part, was that person insane? Who can they make a not guilty by reason of insanity? And on the substantive part, if you apply the McNaughton test, let's see. When this person was hitting the customer, he said, "I'll kill you." Just really freaked out. Now, this person had been in and out of mental institutions all their life. And so we know they had some kind of mental disease or defect. But on the facts that I gave you, I'm not sure you can say that because of the mental disease or defect, he wasn't able to know what. We don't know what kind of mental disease or defect he had. This person may have had the kind of disease where he eats too much, or a disease or some other kind of disease of the mind. Might not have anything to do with violence. So we don't know whether because of his mental disease or defect, he was, under McNaughton, he did not know the nature of his act. Well, I think he knew the nature of his act because he said, I'll kill you. So he intended to hurt this person. California, person has to be incapable of understanding the nature of his act. Well, we don't know that this person was incapable of understanding the nature of his act. Under and finally, or did not know it was wrong. Well, I think he knew it was wrong. He says, I'll kill you. If the burden is on the state to prove that the person knew that it was wrong to kill somebody, they would, bring out relatives and people that knew the guy and so forth and said, did he understand this? If the defendant has to prove I'm insane, they'd have to prove I didn't understand this. In any event, in this case, I think that this defendant cannot make a good argument that he did not know what he was doing was wrong, or did not know what he was doing, or did not know it was wrong. I think he'd fail in the McNaughton rule generally, fail under the federal rules, and fail under California. Irresistible impulse. Person said, I couldn't stop myself when I swung and hit him. Well, that's some evidence, and if his psychiatric testimony supports it, that's his best, one of his good shots possibility. Model Penal Code. Because of mental disease or defect. Well, again, we don't know what his mental disease was. The person lacks substantial capacity. We don't know his disease. To appreciate the wrongfulness, I think he knew it was wrong, or to conform his conduct. Maybe he can't conform, but we don't really know that. And so it depends on who's got the burden of proof. If he has to prove that I could not conform, there wasn't enough evidence for him to prove that. If the state has to prove that he was sane beyond a reasonable doubt and could have conformed, there wasn't enough evidence to do that either. So you just had to leave it. So that's how you would apply all four of these. On the Durham test, we didn't apply product rule. We don't know that this person's conduct in hitting this person was a product of a mental disease or defect, so he wouldn't get in a place for that. So that's how this system works. I think at this point you understand in the procedural areas that the defense must give notice that they intend to use the not guilty by insanity. They have to, some jurisdictions, you cannot prove that the person's incapable of certain states of mind unless you are proving insanity. The defendant must offer some credible evidence of insanity to start to bring the issue up. Once the defendant presents credible evidence of insanity, about half the states of prosecution has to prove sanity beyond a reasonable doubt. About half the states, the defendant has to prove insanity by the preponderance of evidence. In the federal rules, the defendant has to prove insanity by clear and convincing evidence. If you want to prove insane at the time of trial, these are the standards here. Persons can the person understand the proceedings against him, and can they assist? If they're insane at the time of trial, they're committed until they become sane, as long as they're making some reasonable progress towards becoming sane. If they're not going to get sane, then they have to go through civil commitment. And finally, insane at the time of the act. If the person gets a verdict of not guilty by reason of insanity, they're acquitted by insanity, they're going to end up being civilly committed. Here's the way you do it. They get out when they can prove that either they're not dangerous or not insane. The jury is not told what happens to them if they're found not guilty by insanity. With that in mind, we then look at the how do you decide if the person's brain is broken enough. McNaughton says here are the standards. We just went through those. Irresistible Impulse has its standards. Model Penal Code has its standards. And the Durham test has its standards. There's one last thing that I have been delaying telling you about throughout the lecture, and that is here, when we use the language because of a mental disease or defect, a mental disease is thought of as something that you at least think is curable, whereas a mental defect is something that you don't think is curable. For example, if a person is born with an IQ of 60, that you don't think of that as curable. That's a mental defect. Now, if you use these principles that we've just talked about, and you incorporate and use the facts twice as much as you think you need to, you should get an 80 on a question like this. If you use these principles and skimp on the facts, you'll probably get a 65, 70, something like that. But this is an opportunity to rack up some serious points if you just use the facts a lot throughout your bar exam exercise. When you're taking the exam, please keep in mind that if you look at the published answers, you'll see extensive use of the facts. You'll see discussion of the rules, discussion of the law, not just a statement of the law, but some discussion about it. And then you will see extensive use of the facts. And that's where the rest of the points are. And that's the end of this lecture.